I'm Rob McCallum, PIO for the state courts. Thank you so much for being here for this session of Law School for Journalists. And a special thanks to Judge Krieger from the federal courts for coming up with this idea and saying, hey, let's see if we can get this going in about a week or so. And sure enough, we were able to pull it off. We'll defer to our speakers in a second. Law School for Journalists is a program that's done in cooperation with the Bar Association and state courts. We try and bring in subject matter experts who aren't necessarily sitting the bench and can speak their mind about any particular area of interest. We've done this on water law, we've done this on ski law, we've done this on a variety of topics, and thought now would be a good idea to bring Criminal Courts 101, including some conversation on the insanity plea and the death penalty today, just to help people get their minds around what we're doing. As you can see, we do have this available via webinar for those of you who are logged in online. Thank you so much for that. We will also be working to take this videotape today and post it to the state court website as well as the Bar Association and any other places we can get it out there. Traditionally, we have done these sessions as an off-the-record matter. Obviously, today, with this being recorded, we're not going to go that route. You're all free to treat this as a background session, if you will, and then I think you'll get some valuable resources moving forward. So with that, I'll turn it over to Judge Krieger. She's going to talk a little bit about the Our Courts program as well.
When you say background, so you're fine if we tweet about this, if we Facebook about this, that's fine.
No questions at all?
Hi, my name is Marcia Krieger, and I'm thrilled that you're here, and I'm thrilled to be here as well. I sit on the United States District Court for the District of Colorado, the federal court in Colorado, and I also am here as the chair of the executive committee of the Our Courts Project, which is the first in the country in developing education programs about the court system for adults. We've been active since 2007, and when we very first started, we didn't know whether there was any interest in information about the court system, but we thought there might be. And what we found out was there was a tremendous need for information because most people get their information about how courts work from you and from the TV. And so we wanted to present, through judges, information about how the courts work to citizens. And since we began in 2007, we've spoken to more than 10,000 people in more than 350 presentations here in Colorado. The presentation today is two parts. It is a part that Tina Habas will present that's through Our Courts, and then Karen Steinhauser will present a second part about insanity and about the death penalty that is not through Our Courts. And the reason I make the distinction is Our Courts uses judges as speakers to go out into community groups, and we are subject to ethical restrictions which bar us from being able to talk about particular cases or particular issues that are of public interest. We can talk in generality, we can talk about procedures, we can talk about how things work, but we cannot comment on particular cases. So I asked your cooperation, because Tina Habas is speaking on behalf of Our Courts, to tailor questions to what she can talk about, which is the general process of a criminal case. You're free to ask whatever questions you want to ask of Karen Steinhauser, because she speaks outside of the Our Courts rubric, and she speaks as a speaker obtained by the Colorado Bar Association. The second thing that I ask you to do, and you will see this website at the end of the Our Courts presentation by Judge Habas, and that is a website address, and I encourage you to submit any words or terms or ideas that you think your readers or listeners would be interested in having definitions for. We're putting together a glossary that we will post on our website that will give lay definitions to all those terms that may be confusing or may have a popular misunderstanding. We will encourage you to give us what you think might be appropriate in that glossary, and then more importantly, to access those definitions to the extent they're helpful to you and to the extent that you might like to hyperlink them into the articles that you post on the web. So I thank you for being here. I hope the information that you hear is helpful to you and helpful to your audience. Thanks so much. And I want to introduce, before I step away from the podium, Tina Havas. And I refer to her interchangeably as Tina Havas and Judge Havas, and let me explain why. Almost 11 years ago, she appeared in front of me, and she was Tina Havas. She was Ms. Havas in the courtroom. Then she became a Denver district judge in our state system, and she served there for 9.5 years, and I got used to calling her Judge Havas. She reminded me this morning that she's going to be appearing in front of me again, so she has returned to being Ms. Havas, and so
That's in polite company.
So I introduce her to you as both an esteemed litigator and a highly respected judge. She's going to talk about how the criminal legal system works in Colorado.
Thank you, Marcia. I really am still honorable, although technically I can't be referred to as that way. Good morning. Hope everybody is well today. You people in the back, standing room only, there's places up front if you want to come on up here. What we're going to talk about today is some things that you're probably already familiar with in the criminal court system. So you'll have to just bear with me as I give you that context. But hopefully I'll give you some additional insights on different procedures. Now, as Judge Krieger mentioned, although I am here as an hour court speaker today, and I cannot address specific cases at this point, I would also invite you, I am more than happy to discuss cases with you specifically in a different context, but not as representative for our courts. So the whole purpose today is to give you the life of a criminal case from true beginning to the end so that you have a better understanding of it. Now, many of you have covered the courts beat for a long time, I would imagine. Some of you are new to the game. But what generally happens, and what I see in media reports frequently, is that the people who have covered the courts the most often will at times slip up in discussing what the procedures are and calling things by their proper names. And so I think this is probably a benefit for all of us. Now, the first thing is, how does a court case get started? There's two ways in general that a court case gets started. One is called a complaint and information. That's simply the filing of criminal charges through the office of the district attorney. The district attorney has the sole responsibility to determine what charges will be brought in any particular case. The second way, other than an information, is to go through the grand jury system. We're going to talk very briefly about the grand jury system today, but the grand jury system is essentially a grand jury made up of citizens from that particular district, or in the case of the statewide grand jury, from all districts across the state, who listen to information and determine if there is reason to believe that charges are founded, in which case they present an indictment on those charges. The district attorney still runs the grand jury indictment situation, and the district attorney decides which charges to present to the grand jury. But the grand jury gives an up or down vote. Is there or is there not probable cause to believe that that offense has been committed, and they can return that indictment? And so the sole responsibility for those charges is always the office of the district attorney. Now, the grand jury system determines it's an investigative body only. It is not a trial jury, and it does not determine if there is sufficient evidence to support the criminal charges beyond a reasonable doubt. The only people that do that is the jury. So we're going to talk from here on out outside of the grand jury system unless I tell you there's a specific reason to stay in the grand jury system, and we're going to assume instead that the charges have been brought at that time. The role of the jury is simple. The jury looks at the evidence that's presented in court during a trial, and then following the instructions of law that the court gives them at the end of the trial, determines whether or not the prosecution has met its burden of proving each and every element of any charged offense beyond a reasonable doubt. Think of it this way. Think of it like a checklist. At the end of a trial, the main instructions go to the elements of an offense, and every single offense by statute has certain facts that must be proven. The one fact that has to be proven in every single criminal case is identity. The defendant, not somebody else, not somebody pretending to be the defendant, but the defendant, does an action that's listed in the offense and does it with the required culpable mental state. We're going to get into all of those a little bit later, but those make up the elements. So essentially what the jury does at trial is they judge the quantity of the evidence, is it high enough to rise beyond a reasonable doubt, and the quality of the evidence. We're going to talk more about exactly what evidence is and what goes on in a trial later, but obviously we just wanted to introduce the jury at this point. Now, all of a defendant's rights are set out by both the United States and the Colorado Constitutions. In many instances, the state or the Colorado Constitution is much more specific and grants broader rights to the defendant than the United States Constitution does. But think of the United States Constitution as being the bare minimum for what the defendant's rights are in those cases. Among those rights are the following. 1, every person charged with a crime is presumed innocent. How many of you have heard that before? The presumption of innocence, right? What does that mean? It's very simple what the presumption of innocence means, and this is the way I used to explain it to juries. Let's say I want you to think of someone who's close to you, somebody you know well, somebody you trust. And I'm going to tell you I saw that person selling methamphetamine right in the front of the CBA building this morning. Your first reaction ought to be, I don't believe you, prove it. That is the presumption of innocence. The Constitution requires us to give perfect strangers the same presumption of innocence that we would give to someone that's close to us. That is, as they sit there, they're innocent until they're proven guilty. Now, this can be a pretty difficult concept for people. As you might imagine, a lot of times people will make the supposition, well, if they're here, they're sitting in a courtroom, they had to have done something wrong, right? So it's counterintuitive. And that is probably the centerpiece of the criminal process, is that they must be proven guilty. And until they are presumed innocent for all purposes. Also among those rights is the fact that the defendant has the right to remain silent, and the defendant has a right to counsel. There are some other rights that we're going to go into later that are procedural, but those are the major rights that we're going to cover today. Now let's go to the first appearance in court. Very first appearance has to happen very quickly after the charges are filed. Whether it's an arrest based on a grand jury warrant for an indictment, or an arrest warrant, or even arrest by a police officer on the scene, a warrantless arrest. They have to be brought as quickly as possible for their first appearance in court. And the whole point of that is first to advise the defendant of what the charges are against them. There is not necessarily a requirement when the person is taken into custody that they be advised of all the charges. That's because the district attorney makes the decision about charges. The police make a determination if they have probable cause to take the person into custody, which means a reasonable belief that a crime has been committed. But ultimately, the charges aren't made until the district attorney decides what those charges are going to be. Sometimes the charges are identical to what the police officer making the arrest wanted to do on scene. Other times they are not the same, so the defendant is fully entitled to be advised of those charges. The defendant is also advised of the rights. Among those rights are the fact that they are presumed innocent. Furthermore, they have an appointment of counsel at this stage. If they cannot afford counsel on their own at their expense, and they prove that they are indigent, then they have the right to appointed counsel at no charge to them. The Office of the Public Defender makes the determination if someone is indigent or not. There are two ways for you to be determined to be indigent for appointment of counsel. The first and quickest way, if you are in custody, you are presumed indigent for purposes of appointed counsel. The second way, if someone is out of custody on bail, they must prove by giving information about their economic situation that they are indigent and thereby allowed to have appointed counsel. We have two types of appointed counsel in the state of Colorado. We have the Office of the Public Defender, which is the very first line that we go to for the defense. But in the event of a conflict of interest, for example, if the public defender's office is currently representing someone who may be a witness in this defendant's case, there might be an ethical conflict of interest. We go to the Office of Alternative Defense Counsel. And these are criminal defense lawyers in private practice who make themselves available for representation to indigent defendants at a very, very low rate. It's something that the criminal defense bar has done for a really long time, and believe me, the courts would suffer if we didn't have those folks making that kind of a commitment. So that's very important to all of us. The next thing that they're advised of is speedy trial. Now, speedy trial requires that you be tried within 6 months of the date of arraignment. Not 180 days, but 6 months. If you are not tried within that period of time, and there is not good cause shown for an extension, the case must be dismissed. So 6 months is speedy trial. You are also told about your right to have a jury trial if imprisonment is an option in your case. There are, for example, some traffic infraction cases, those sorts of things that are technically criminal, but because incarceration, imprisonment is not a requirement or a potential sentence, you're not entitled to a trial by jury on those kinds of offenses. But if imprisonment is possible, you are entitled to a jury trial on all of those cases. Now, another thing that happens in the first appearance in court, and you've probably seen this in many cases, in fact, we've seen this recently, in the Trayvon Martin case, bail is argued. Reasonable bail is required in almost all cases. And I say almost because there are exceptions. Capital offenses do not allow bail to be set where, and this is an important phrase, proof is evident and the presumption is great. Let me repeat that. Where proof is evident and the presumption is great, on a Class 1 felony, you are not allowed to set bail and the defendant must stay in custody. That particular claim, and the prosecution is the one that makes that claim, has to be determined by the court. It's essentially a trial to the court at a separate hearing. So I'll say that phrase one last time, proof evident and presumption great, because that's a pretty important one in capital cases. Now, we have passed over specifically another kind of hearing, and that is a preliminary hearing. We're talking today about the first appearance in district court. There are a couple of other appearances that may happen in county court, including something called a preliminary hearing that happens before the arraignment. The purpose of a preliminary hearing is in cases that were filed by a complaint and information only, not with a grand jury, is for a judge to decide, is there probable cause to support the charges. So the proof evident presumption great hearing can be combined with a probable cause hearing. And essentially the prosecution then has the burden of establishing what that proof is, what that level of proof is that the defendant is likely to have committed the capital offense if you want to deny someone bail. So this is probably a new procedure that many of you have never really heard of. It doesn't happen a lot. When I use the term capital offense, I mean a Class 1 felony. And there's really, for our purposes in Colorado courts, only 2 Class 1 felonies. Murder in the first degree and kidnapping in the first degree if the person kidnapped is injured. Okay? So those are the 2 specific cases where bail is denied. Now let's look to the great majority of the cases where bail is granted and how you determine bail in the first place. Well, the court is required to look at several things. First off, most districts have a bond schedule. The purpose of a bond schedule is to give the judge some some amount of consistency so that depending on who the judge is setting bond, you have an idea of what other judges in your district consider reasonable bond to be in those kinds of cases. And so the bond schedule is generally attached to the classification of felonies. I should ask, how many of you understand that there is a classification of felonies in the state? Or is this a different concept for you? You've all got that down. Great. We have 1 through 6, 1 being the highest. So if we're going to set bond, we want consistency. We want fairness. The whole purpose of bond is to ensure a defendant comes back to court when they're ordered. And so essentially, depending on the severity of the offense, depending on the potential seriousness of the sentence that might be involved, you set bond higher or lower to make certain that people can come. Now, there are several cases where bond is set at a certain level and the defendant cannot make bond. For example, even if you have a Class 6 felony, if someone is homeless, it's going to be difficult for them to find any kind of bond and meet it. So when you're setting bond, you recognize as a judge that the purpose of bond is to ensure the defendant's presence, not for punitive purposes, not for anything else. And so the factors that we look at is the seriousness of the charge. Is this person a flight risk? For example, are they a naturalized citizen, for example, and they have a passport, and they have family outside of the country? Have they said to people, I'm going to run? Have they run before? Have they failed to appear at another criminal proceeding recently? All of those things are factors that come into whether or not someone's a flight risk. Do they have a criminal history? In many instances, the sentencing will be higher if you have a criminal history, because if you have a recidivist, obviously one of the issues you look at in sentencing is, do I want to make the sentencing higher? Think of it when you're disciplining your children. The first time somebody does something, fine. Maybe that little slap on the wrist. Second time, not so much. All right, maybe the cell phone goes away. Who knows? But you have to look at that criminal history. All right, now, the first big thing that a defendant must do is to enter a plea. And there are 3 pleas. There's guilty, there's not guilty, and there's not guilty by reason of insanity. We're going to talk about each one of those in turn. At any time, a defendant may choose to enter a plea of guilty. Generally, that will happen as a part of a plea bargain. We're going to talk about that a little bit later. But if a defendant wishes to plead guilty either to the crime as charged or to a different crime based on negotiations, they may enter that plea at any time unless the judge sets a date beyond which a disposition will not be accepted, in which case they will procedurally go to trial. A judge might do that, for example, if I have 200 jurors coming in on a massive case. I don't want to have 200 citizens coming in at any given time down for a trial that then doesn't happen. Because, let's put it this way, jury service works a hardship on citizens in this community, and we know that in the court system. We rely on jurors, and that's why we sometimes will set that. It's the exception rather than the rule that a judge will set a mandatory disposition date, but in certain limited circumstances they will do so. Now, a not guilty plea is the one that we see, 99.9% of the time at the arraignment. But then the not guilty by reason of insanity is a completely different animal. Now, here's where I want to talk about 2 concepts, and they are combined. I'm going to go straight to the next slide because we're going to talk about the issue of competency. Think of it this way in terms of timing. Competency is a question of whether the defendant can participate meaningfully in their own defense now. In contrast, insanity goes to the date of the act forming the basis for the criminal charge. That is the major difference between the 2 of them. But beyond that timing difference, there is a completely different definition for the 2 concepts. So let's begin with competency. The procedures for raising competency, it can be raised at any time by the defense attorney, by the prosecuting attorney, and under certain circumstances, by the judge. For example, if I see very unusual, strange behavior with a defendant, and I am advising them of the charges against them, and they are asking very inappropriate questions that don't have anything to do with the conversation we're having, I myself might say, I have a question about this defendant's competency. Most of the time, the lion's share of the time, competency is raised by defense counsel. The way it is raised, if the attorneys raise it, is a written motion with a statement of good faith belief for the basis of the incompetency claim must be stated in the motion. If a defendant is found incompetent to proceed at any time, the criminal proceedings must stop. Nothing further can happen. So by way of an example, let's say you have a defendant come in for a first appearance, and then even a second appearance, and a preliminary hearing, and then they get scheduled for the arraignment in district court, which is my first appearance. And at that time, someone raises competency, everything stops. Speedy trial does not run. There's a timeout on speedy trial. And no further proceedings that do not relate to the competency determination can take place unless they do not require any participation by the defendant. So, for example, there might be some motions hearings that can go forward that don't require the defendant's testimony, for example. But everything else, a halt is put on it. And essentially what happens, the defendant is then seen by a mental health professional. In general, we either have a psychiatrist or psychologist either come to the jail where they are if they're in custody, or we send them to the Colorado Mental Hospital in Pueblo for a competency evaluation. In the unusual circumstance where you have someone who is claiming incompetency who is out on bail, you may make a condition of their continuing bond that they show up for certain evaluations. So it's that evaluation that takes precedence over everything. Now, as you might imagine, the workload at the mental hospital in Pueblo is extremely high. And for that reason, there is generally a fairly lengthy delay in any case where competency is raised. You hope it's about 90 days. Yes, ma'am?
Does all parties have to agree on the psychiatrist who is
The question is a good one. Do all parties have to agree on the person doing the evaluation? The answer is no. As a matter of fact, what happens is no one identifies it except for the state hospital, identifies who will be doing the evaluation. If a defendant wishes to have a separate evaluation, they may ask for that, but it is not paid for by the court. And it's a question of who's then going to pay and arrange for that to happen. Now, the court then, once a report is given back, the court makes the initial finding competent or incompetent based on the report. Either side, but most likely the defendant, may object to that finding and request a hearing. Remember, speedy trial is still timeout during all of this happening. This hearing is to the court, and either side may present evidence on the issue of competency at that time. The court then makes the final determination about whether someone is competent or not. If a court finds that a defendant is incompetent, depending on the classification of felony, that defendant is generally sent to the state hospital until they are restored to competency or until the length of time that they'd be looking at for their maximum sentence is done. So, for example, if someone is held at the state hospital on a competency issue, you may not hold them for longer than the sentence would have been if they had gone to trial and been convicted. Insanity is different. We'll talk about that in a second. On the other hand, if the judge finds someone is competent, depending on when competency was raised, if it was raised at that first arraignment, speedy trial then gets set 6 months from that date, and trial must be set within that time. On the other hand, if it was raised at some other time in the proceeding, speedy trial is tolled. You just stop the clock. It's like a stopwatch. And then it resumes from that date. So let's say 1 month after the arraignment, the defendant raises competency. Stop. We have the hearing. The defendant is found competent to proceed. We then have 5 months left on that speedy clock. All right? Competency can be raised at any time, including trial. But needless to say, if it's raised during trial, perhaps the court requires a bit more by way of a showing, so that we can guard against the possibility that someone is using it as a tactical advantage. But I have to tell you, in my experience, criminal defense attorneys and criminal prosecutors are generally of the highest ethical standards, and that sort of gamesmanship does not happen. That's just kind of an aside from me. All right, so once we determine competency, and I guess I do have to go backwards to talk about insanity, because I'll bet there's some questions about insanity as well. Now, I'm going to read this carefully. I know Karen has this on a couple of slides, so I would not try to write this down. I'm going to talk pretty fast when I read this. The definition of insanity in Colorado for any act committed on or after July 1st of 1995. And this is found, for those of you who know the Red Book sites, Colorado Revised Statutes 16-8-101.5. A person who is so diseased or defective in mind at the time of the commission of the act as to be incapable of distinguishing right from wrong with respect to that act is not accountable for the crime. Care should be taken not to confuse such mental disease or defect with moral obliquity. I love these words, don't you? Mental depravity or passion growing out of anger, revenge, hatred, or other motives, and kindred evil conditions, as to those the party is accountable. All right? Another possible way to bring it in is if someone has a mental disease or defect that prevents them from forming a culpable mental state. That would be either after deliberation and with intent, in the case of first-degree murder, or specific intent to harm or cause serious bodily injury to someone. So that culpable mental state, somebody might just not be able to do that. Now, the obvious question is, what about somebody who's twinked out? Somebody who's drunk out of their mind or been taking drugs for a long time? Voluntary ingestion of any substance does not entitle you to claim insanity. So there's many cases out there where someone just does a lot of crack cocaine. Yes?
Does that include psychotropic drugs that might be prescribed for a mental illness?
Now, prescription, it's possible. That's a really good question. But in general, a prescription medication may or may not entitle someone still to claim that. But under the statute, a voluntary ingestion of substances does not entitle you to claim insanity. So essentially, what the courts want you to do in determining a not guilty by reason of insanity is determine, is this person ill or are they just evil? And there's a difference. Now, yes, ma'am?
It's so subjective.
The question is, how do you prove it? It's very subjective. Well, this is getting ahead of me, but I'm going to get to it right now. Everyone is presumed sane, unless the defendant brings forth some evidence that they were insane under that definition at the time of the commission of the offense. If they do that, then the prosecution must prove sanity beyond a reasonable doubt. Things such as this. Did the person try to run? Did they hide the commission of the crime? Did they fabricate a story if they were talking to people about it? All those seem to indicate that they knew that they had done something wrong. So those are the kinds of things that you would generally look to prove sanity. Yes, ma'am?
What about intent?
Now, the next question is, what about intent? Intent must generally be proven by circumstantial evidence, because we rarely have direct evidence where someone says, by the way, I'm going to take this gun and I'm going to blow your head off. It is generally by circumstantial evidence, and the law makes no distinction between the effect of direct and circumstantial evidence. And so the jury has to determine, is there enough to show that this was intentional or not intentional? And that varies on a case-by-case-by-case basis. But it's another good reason why we have a jury trial. When you have 12 people looking at the same evidence, if they are all convinced beyond a reasonable doubt, it gives me a lot of confidence. But you're right, it's very subjective in many, many cases. And sometimes the case will hinge, whether you get a conviction or an acquittal, will hinge on that culpable mental state. That's the big one, every time. Okay? Now, not guilty by reason of insanity, we used to try it in 2 separate trials. But now it is combined. You may ask for a jury, or both sides may waive the jury and ask the judge to make the decision. That happens, actually, it's more common than you might imagine. The last time it happened in Denver that I can recall was Amber Torres. I was the judge presiding on that case. Ms. Torres was charged with murdering 2 people. There were competency issues raised in that case, so if you want to look at a good case that shows you how these 2 things dovetail, that's a good one. And there was also a not guilty by reason of insanity that was entered as a plea in that case. There are others, I'm sure, in other jurisdictions that I'm just not aware of. All right, now let's go to the next phase, which is something called discovery. A defendant is entitled by the rules of criminal procedure to know almost all of the basic information that the prosecution has. There is no holding cards to the chest. There is no poker. There is no bluffs. Things such as any investigation material, reports, photographs, witness statements, measurements, ballistics, those sorts of things. Any physical evidence that they've taken either from the scene or elsewhere that may have something to do with the case. Any recordings that were made that include, but are not limited to, the 911 call if there was one. Or let's say there were recording, in several cases we had tape recordings that were made when someone was in the Denver County Jail and they called people outside and those phone calls were recorded. That was in the Colonian Clark murder trial. We had a significant amount of those. Witnesses' names and addresses. Now, sometimes those witnesses are also victims, and those victims' addresses can be under the office of the district attorney, because there are many cases where you don't want to give up the current address of one of the victims. And overlying this whole process is the Victims' Rights Act that we'll talk about a little bit more later, because it has much more to do later in the case than it does right now. But all of these materials have to be given up. And then finally, if there is anything at all that the district attorney knows about that may seem that it's exculpatory or make it seem that the defendant is not guilty, they must give it up. Period. The district attorney cannot make its own determination tactically. Well, this isn't really exculpatory. It's only this much exculpatory. It's really up to defense counsel to make that decision. Because the fact of the matter is the DA doesn't know all of the tactics that's going on with the defense. And so it's a very, very high obligation. And it is a continuing obligation. It goes all the way through trial. So we have had situations where we're in trial, and the second day of trial, the district attorney asks to approach the bench with defense counsel, and they'll say, Your Honor, we had a witness come forward yesterday that said that this guy didn't do it. And I just heard about this, and I'm giving it to the other side. They've got to come forward and do it. Because in essence, the job of the district attorney is not to get convictions. The job of the district attorney is to do justice. That is why there are so many obligations put on the office of the district attorney. And the judge essentially has to referee those obligations. Well, it doesn't seem very fair if the defense doesn't have to give anything up. So the defense does have to give certain things to the prosecution. For example, non-testimonial information that might be fingerprints, a voice ID, handwriting analysis, DNA tests, hair follicles, things like that. That can be provided. Also, if they are going to call experts on anything, they must exchange that information, the opinions and the basis of the expert. Because in many instances, the district attorney might want to call their own expert. The nature of their defense. What is their defense? Is their defense simply, you can't prove it? What I call the Bart Simpson defense, you can't prove it. All right? Or is it something specific? It wasn't me. Or I couldn't have formed the culpable mental state, or something like that. Or notice of alibi. And when you think about it, it's a fairness issue. If the defense is going to get up and say, I wasn't there, and I'm going to call a witness to say I wasn't there, the prosecution should be allowed to investigate that. Because many times they might investigate it and find out it's true. And then the district attorney may change their opinion about the plea or the charge. And so that is why the defense must give that sort of discovery. The defense is required to do this as soon as practicable, but in all events, no less than 30 days before trial, as a fairness issue. So let's go to what really happens in 90% of the criminal cases in this state, plea bargaining. If we tried every single case that was filed, and I'll give you information about the number of cases that have been filed in 2011, we'd be bogged down hopelessly. We couldn't do anything. So plea bargaining is really the heart and soul. The considerations that the prosecution has to look at are the following. What's the kind of offense? What does the victim think? And that's not just as a matter of justice. That's required by the Victims' Rights Act. Can a victim blackball a plea bargain? No. The victim does not have sole power to do that. However, the victim's position on a plea bargain may carry great weight, depending on the case. And in certain cases, as you might imagine, there's going to be a lot of victims. Darren Williams, 17 victims in that limousine. And all of them had a say in what's going on. Do I need to just move forward quick?
We've got about 3 or 4 minutes on this portion of the program.
Okay, you have the slide for this. I'm not going to read it to you, all right? Judge is never involved in plea bargain. Never, 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 ever. Never. Pretrial issues are those legal issues that the court has to determine before the jury looks at the case, including, but not limited to, whether or not there should be evidence suppressed, either because it was unconstitutionally obtained or other reasons. Another thing that has to be determined is what are called other bad acts. That's a 404B. Colorado Rules of Evidence, 404B. If I did something on another date, you can't bring it to show that I did something the same on this date unless it has some independent significance. Because as you might imagine, if you tell jurors, this guy did an assault 2 years ago on a woman, the jury might just say, oh, well, okay, of course he did it today. It's no substitute. So there are very specific circumstances that you can use other bad acts. The phases of the trial are also on here, and the ones I want to talk the most about are the presentation of evidence and the instructions of law. Evidence consists of only 4 things. Testimony of witnesses sworn on the stand. Not the questions of the attorneys, not the objections of the attorneys. Pieces of information that are received as exhibits. Things that are agreed to or stipulated to. And in rare instances, something called judicial notice. For example, I don't have to bring a witness in to prove that the sun rose in the east this morning. We all know it's true. Let's say that's important in a case. I can take judicial notice. I can also take judicial notice of things that happened in my court on certain dates. That is it. That's the evidence that the jury weighs in determining, did the prosecution prove beyond a reasonable doubt all the elements. Second thing I want to talk about is the instructions of law include definitions. It includes other cautionary instructions to the jury about certain types of evidence. And that's what governs the trial. And then finally, the deliberations and verdict. What happens next? If the defendant is found not guilty, the case is dismissed. The defendant is released if they're in custody. Their bond is exonerated if they're not. If it is not guilty by reason of insanity, the defendant is institutionalized immediately. There are obligations on the state that allow a defendant to ask for a release. I'm not going to go into those. I think Karen probably will on those. But if you want to talk about that further, you can always call me. If they're guilty, there's a judgment of conviction. And before the sentencing hearing is set, two things have to happen. The victim has to be given the right to speak at the hearing, and a pre-sentence investigation report is prepared to tell the judge what the sentencing options are, tell us the background of the defendant. Is there anything going on in their social background, their history, their criminal history? Anything happening? Do we have dependency issues? Things like that, alcohol or drugs. And we take a look at all of those things. The consideration at sentencing, essentially you have three possibilities. You've got probation, which means the defendant is on their own under supervision. You have a couple levels of probation, regular probation and intensive supervised probation. Then you have community corrections. A lot of people call that a halfway house. The only option beyond community corrections is prison. You all know the difference between jail and prison. I didn't used to. Okay, just for everybody to know, jail is in the county. Generally, it's pre-trial in a felony situation. Prison is after. Big difference. And restitution must be considered by the court in any case where there is a victim and they may have had losses. Many times the restitution is millions of dollars. We had a firebombing at the Holly shopping centers. Millions of dollars. These kids have no chance of paying it, but restitution nonetheless must be considered at that time. Victims are entitled to address the court at sentencing. It is their right. The factors are in your paperwork, so I don't have to go through all of those, obviously. And the appellate process is also in there. The Court of Appeals is the first line of defense. There's 3 court panels on the Court of Appeals. Any case may be appealed to the Court of Appeals. We then have the Supreme Court in Colorado with 7 justices. They either choose or not choose to hear cases. It is always their choice. And then ultimately the U.S. Supreme Court in very, very, very rare circumstances. Here's the statistics, folks. You can see how busy the criminal courts are in this state. And all of these cases get heard with all of this due process. All right, I appreciate your attention very much. I know that you're eager to see Karen. Are there any other questions before I sit down? Yes, sir.
I just wondered if you could, maybe Karen's going to just the procedures for sentencing death penalty cases.
I think I'm going to leave that for Karen because that's beyond the scope of what I am talking about today. Yes, sir.
When there is a sentencing hearing, does the judge have already their mind made up about sentencing before the hearing starts?
That depends on the judge. There are some mandatory sentencings that have no discretion. For example, a capital offense requires, if a judge does it, life in prison without the possibility of parole. It's a no-brainer. You can't do it any other way. But I can only speak for myself. I had an open mind until I heard from that defendant because the defendant has the right to talk to me before I impose sentence. And frequently, that mattered to me. I think I need to sit down because Rob is standing up. I appreciate your attention. If you do need to contact me, I'm happy to talk to you. Thanks.
Thank you, Judge Habas. And I don't know, we're trying to keep this on track today. I don't know what Judge Habas' schedule is or Ms. Steinhauser's, but if they're available after to stick around for a bit, we'll take more questions. But in the interest of getting the subject matter out, we'll do that today. We're going to turn it over. Oh, one quick note, because I know we've got people in the room who love paperwork. Judge Habas mentioned pre-sentence investigation reports. For the record, those are not public records. I get that question all the time, so don't come looking for them because I can't give them to you. Karen Steinhauser, we're going to turn it over to her. She is practicing in Steinhauser Law, so I assume that's your own firm, criminal defense and high conflict family law. Prior to entering the private practice in 2001, I believe 20 years at the Denver District Attorney's Office, both as a chief deputy and deputy DA. So lots of good things to come out right now regarding the insanity defense and plea, as well as the death penalty. So with that, Ms. Steinhauser.
Good morning. Couple things I just want to say first is even though our focus is talking about the incompetency issues, insanity issues, and death penalty, if you have any other questions about some of the other issues that are going on, I am happy to at least try to answer. The other thing I want to say, because I know I've been doing some legal commentary, and I've done that in some other cases, I just want you to know I do not have any inside information that the rest of you don't, okay? I find out a lot about this case from what you all report and write. So my insight comes from having been practicing mostly in the criminal arena for 30 years, being a DA, being a defense attorney. I know the public defenders in this case, at least one of them, fairly well. I know the prosecutors, but I do not have any inside track that you all don't. So I want to make that as a caveat first. In terms of, let's just start talking incompetency and insanity a little bit more. Your slides have the actual legal definition along with the statute number, so you know what we're talking about. One of the things that I do want to tell you, though, is that even though there is this formal process during the court process where somebody can raise the issue of competency, that oftentimes, particularly in a high-profile case or even not, defense attorneys often are hiring doctors, psychiatrists privately before there's anything in open court that raises the issue. Why? Because what happens when you raise incompetency as an issue is that the judge orders that a report be done, and that report gets shared with the prosecution, with the defense, with the judge. As a defense attorney, if you have a private evaluation done. In other words, I've done it where I've hired a psychiatrist on my client's behalf. The psychiatrist will meet at the jail. Generally, we try to make it so no one from the outside knows who that visitor is or anything else like that. And I get a report that I don't have to share with anybody unless I choose to do so. Prosecutors can't do that. We couldn't, we wanted to talk to the defendants when I was a DA, but they can't. But I can guarantee you, I think in this case, the defense is probably conducting their own evaluations now so that they have a sense themselves of what's going on with their client before they then make the decision as far as whether to raise it so that then a report gets generated for prosecutors and defense. So oftentimes the private reports get done first. The law defines clearly incompetency and insanity, and it talks about competency as being a mental disability or developmental disability, with two concerns there. One is either that it makes it so that the defendant can't sufficiently assist their attorney in their defense, or alternatively, that the defendant doesn't have a rational and factual understanding of the issues that are going on in the case. And as Tina talked about, that can be raised at any time. And I know some of you, there were a lot of questions, particularly the first court appearance, of the defendant in this particular case as far as looking kind of out of it, was he on medication? A lot of questions get raised that we don't know. We leave it to the experts to evaluate, to try to figure out what's going on. I will tell you that with regard to experts, that you could have 6 doctors examine a defendant and have 6 different opinions. And I will just tell you, just as with any other expert in any arena, that there are experts who may have a reputation as being more defense-oriented. There are experts who have a reputation, perhaps, of being more prosecution-oriented. So, don't expect that we're going to have issues raised as far as competency and insanity in this particular case and have experts who are across the board in agreement one way or the other. And so oftentimes then in those types of cases, that's when you'll see a hearing, when that issue gets determined. All right? So in your packet, there's definitions of what mental disability means under the law, developmental disability. The issue becomes, do you have people that can be restored to competency? And the answer is yes. Sometimes, depending on what the issue is. And I've had clients that with the proper medication, they were able to be restored to competency. There are some people, some defendants, who may never be able to be truly restored to competency. And those are the ones then that may be in the hospital. As Tina talked about, the maximum period of time is until their sentence would have run out.
So, I mean, if there's somebody who can't be restored to competency, who is accused of murder, they could spend the rest of their lives in a state mental institution.
Yes.
Is there a length of time that restoration period could take place? I mean, could it be years or decades, and then suddenly one day they're competent and we go to trial?
The question is, the first question is, so could a person be then, if it's first-degree murder and they aren't restored to competency, could they be in the state hospital then the rest of their life? And the answer is yes. And then the other question was, would you repeat it again?
So it was the period for restoration. If it's, could that take years and then suddenly somebody's competent and you can go to trial then?
The period for restoration can take, the question is, how long does the period for restoration take, and can somebody go to trial? And the answer is yes, as long as it's during that period of time that a sentence would not have run out. Because remember, everything is stopped when it's a competency issue, so there is not a concern about speedy trial. The only parameters are that the person, so for example, let's suppose that you have somebody that the sentence would have been, a 2-year sentence if they'd been convicted. So you can't now, 2.5 years down the road, somebody says they're restored to competency, and you can't then go to trial on that case. But homicide is the question whether somebody, even after a few years, could be restored to competency. Could you try them then? And the answer is yes. You could, if that's a decision that gets made.
If you know enough, talk about the Dunlap case in this case, because he was competent, obviously, to stand trial, and he's on death row. But in the appeals process, not only before the 10th Circuit Court did the defense bring up the issue of, was he properly represented, but now, obviously, there's not a competency issue, but the insanity. The allegation is that he is not, he's mentally ill, and he's not, fit to be executed. How can that not have come out at trial 20 years ago?
Well, the question is about the Dunlap case, and I will tell you, I do not know. I know that case in terms of the appeals process. I have not been following it. But I will tell you that when we're talking about appeals in a death penalty case, you are going to see a multitude of issues that are being raised. And that is why, and we'll talk about the death penalty shortly, but that is why the appeals process in a death penalty case can go on for years and years and years, is because there may be so many different issues that get raised. And one of the things defense attorneys are trying to do, appellate lawyers in death penalty cases, is make sure that no stone was left unturned. Make sure that if there was something that should have been raised back then, well, now it needs to be raised, or why wasn't it raised? And the argument that this is a reason why this case needs to be reversed. So when we're talking about appeals, particularly in a death penalty case, we are talking about every conceivable issue that's going to be raised. Because in a death penalty case, I will just tell you that the main concern of the defense is keeping their client from getting executed. Right? All right, so some other definitions. We talked about anybody can challenge competency, has to prove it. Let's talk about insanity. Now, one of the questions that I've been asked during the course of this case is, what about the planning? What about the preparation that we know the prosecution is going to be arguing? We know that, at least from what you all are reporting, right, evidence that this has been planned for quite some time. And the question then becomes, doesn't that negate then the issue of insanity? And I will just tell you, no, it does not. That in looking at the issue of insanity, the fact that somebody may have been planning something, if that's the case, for a long period of time, while the prosecution is going to be arguing that that shows clearly intent, that shows after deliberation, it also doesn't speak to what was the person's state of mind during that time. Because if you have somebody who is schizophrenic, who is delusional, who is psychotic, who has truly believed for whatever period of time that either they are a different person or that, I've had clients that have auditory hallucinations of being told they're supposed to do certain things, right? That may not just be on the day in question that we're talking about in July. That could be looking at that history going back months. So the fact that you see evidence of planning, I don't believe is the indicator that that person then must have been sane at the time. So the prosecution's going to be looking at all of that. Both sides are going to be looking at so many different things. I guarantee you that there are people probably out talking to family friends, talking to people who have known the defendant for most of his life. There are going to be requests made for school records, for any kinds of records of any kind that are going to help both sides be able to figure out what was going on in this person's head. Because, of course, from the prosecution side, what they need to be able to prove is that, beyond a reasonable doubt, is that he was absolutely sane at the time.
About the burden of proof in these types of cases, and maybe that's a future slide if it is.
No, that's okay. In terms of insanity, the prosecutor, so what happens is the defense raises this, and if a defense raises the issue of insanity, then the prosecutor at a trial has to prove beyond a reasonable doubt that the defendant was sane. So essentially, they have to prove all of the elements of first-degree murder and the two ways in which they've charged first-degree murder in this case. They also have to prove, in addition, that he was sane if insanity is raised. Now, with regard to insanity, there's actually two possible tests of insanity. The one that Tina talked about in terms of it, not being capable of distinguishing right from wrong. But there's a second part of that now, too, that used to be what we called an impaired mental condition. And what that is a person who suffers from a condition of mind caused by a mental disease or defect that prevented the person from forming the culpable mental state that is an essential element. So what are we talking about that? We're talking about the issue of intent and after deliberation. We call that a specific intent crime, as distinguished from a mental state of knowingly. And let's talk about the two different charges in terms of the first-degree murder that the prosecution has charged. The first one is the one that we're most familiar with, and that is intent to kill after deliberation. What this part of the insanity section says is that if the person suffers from a condition of the mind that enables them to not be able to form the specific intent, that would be a defense Not that they're not accountable for first-degree murder in the sense of the first part of the insanity, but more it's something that could possibly take it down to a second-degree murder in terms of the intent and after deliberation. Basically, that they couldn't form the intent. Now, with the second way in which the prosecution has charged first-degree murder and actually the attempted first-degree murders, that is the extreme indifference to human life. There is no requirement that a defendant had to have intended to kill anyone. It is a total just knowingly. That they knowingly, for example, and when we explain what the extreme indifference is, we talk about the fact somebody fires into a crowd. Maybe not intending to kill any particular person, but the idea being that it is an extreme indifference to human life with the idea that there could be grave consequences as a result, and that somebody could die and that somebody did die. So in terms of a defense that would take it out of that portion of the first-degree murder, insanity, the second part of the insanity does not. And the second part is kind of similar to what we call voluntary intoxication. So if somebody were voluntarily intoxicated, voluntary intoxication is a defense to what I referred to as a specific intent crime. It can take away the portion that requires a person to act intentionally and after deliberation, just so that it could take it down to second-degree murder. So in the extreme indifference statute, say we had voluntary intoxication, it wouldn't have any effect on that statute as far as first-degree murder. I don't know if that makes sense. It's
But that couldn't be like, I'm schizophrenic. In the past, I knew that I maybe had tried to hurt somebody, and then I went off my meds. You know, because I remember in the Bruce O. Eastwood trial, the fact that he knew he was schizophrenic but wasn't taking medication that wasn't able to be really used by the prosecution.
You know, I mean, the issue is going to be if somebody has a mental disease or defect, they're going to be looking at, did they have a mental disease or defect? You know, it's going to be an argument in terms of, well, if the person knows that, then shouldn't they have been on the meds? The issue under the test of insanity is, do they suffer from a mental disease or defect? Not do they suffer from one that could have been helped if they had just stayed on their meds. Does that become an issue in terms of their mindset, in terms of how they're thinking, what they know? Absolutely. Absolutely. So there's some definitions I have in the packet, too, of mental disease or defect. Let's talk about the death penalty. You know, and this gets into, you know, the requirement is that under the law, the prosecution has to determine within 60 days after the arraignment whether they intend to seek death. We are so far off from arraignment. None of the hearings that have happened are arraignments. The arraignment is the time where the defendant pleads guilty or not guilty. There are so many things, I will tell you, that are most likely going to happen in this case before we get to an arraignment in this case. And that includes issues around the competency of the defendant, issues around discovery. You have to understand that there are thousands and thousands of pages of discovery, you know, pages of witness statements, so many things that the prosecution and the police are gathering. And the defense has a right to be able to read and look at every single one of those. And I will tell you that even though they waived the 30 days to preliminary hearing, and the reason is every defendant who's charged and is in custody particularly has a right to a preliminary hearing with regard to these charges within 30 days. It is the defendant's right to be able to waive that. They are the only ones that can say, I waive the 30 days. I would be surprised, even though the hearing is now set in November, given the issues, given the multitude of discovery, I would be very surprised if a preliminary hearing happened in November. After the preliminary hearing, generally there is not, the arraignment doesn't occur the same day as the preliminary hearing. So oftentimes, once there is a preliminary hearing, the arraignment could still take place well down the road, well after the first of the year, because, again, the defense attorneys may request additional time to determine, they may feel they need additional time to determine exactly what plea they're going to enter in terms of is it not guilty by reason of insanity. So that's why I think we are way far away from the decision being made. I think if I had to predict, and there was an article in the newspaper too, that it is going to, the decision will be made by one of two other people, not Carol Chambers, because there will be an election in November. One of the things that I do want to say in terms of the Victims' Bill of Rights, as I know Tina alluded to, we are seeing it now. The Victims' Bill of Rights requires, in Colorado, that victims and families of homicide victims be notified about every critical stage in the proceeding. It just requires that. You know, it should be happening, it should have been happening without a Victims' Bill of Rights, but that's why the Victims' Bill of Rights kind of came about, because prosecutors weren't doing as good a job as they needed to with making sure that victims were informed, making sure that victims were consulted. Victims have to be consulted about anything having to do with plea bargains, anything having to do with critical stages. For example, if in any criminal case, if there's going to be a motion to reduce the defendant's bond in a case, the prosecutor cannot agree to that reduction without having consulted with the victim in that case, if it involved a victim, and letting the judge know exactly what the victim said. Doesn't mean that the prosecutor has to go along with it, but they have to be consulted. So from a resource standpoint, if you can imagine in this case what just the victim piece and the victim notification piece is like, it's an enormous responsibility for the prosecution, but it's something that has to be done. So we get the decision in terms of the death penalty, and in terms of making that decision, the prosecutor has to just have one, what we call aggravating factors, in order to seek the death penalty. There are actually, there was like 17, I believe, aggravating factors in Colorado law by which a prosecutor could seek the death penalty. I highlighted what I thought were the ones that the prosecutor is going to be looking at more in this case. First one is under F, that the defendant committed the offense while lying in wait from ambush. Right? Another one is, in the commission of the offense, the defendant knowingly created a grave risk of death to another person in addition to the victim of the offense. Another possible aggravating factor in this case is the defendant committed the offense in an especially heinous, cruel, or depraved manner. Another one is the defendant unlawfully and intentionally, knowingly, or with universal malice, manifesting extreme indifference to the value of human life generally, killed two or more persons during the commission of the same criminal episode. Or another factor is the defendant intentionally killed more than one person in more than one criminal episode. Right? Then the statute also goes on to list all of the mitigating factors that a jury gets to consider. And I will tell you that when the prosecutor is making a decision on the death penalty, not only are they looking at does this fit into an aggravator, but they're also looking at what is the mitigation in this case, because the prosecutor has to look at, is this a case where the chances are great that they're going to get the death penalty? Because if a prosecutor is looking at a case and maybe it fits into one aggravator, and they look at all of the other mitigation in this case, one of the things that the prosecutor knows, that, and I did a death penalty case, is that even though under the law, when a prosecutor goes to trial in any kind of case, the prosecutor has to prove each and every element beyond a reasonable doubt, I will tell you that if death is a part of that, if it's a death penalty case, I don't believe that the burden really is beyond a reasonable doubt anymore. I believe that it unofficially raises the burden for jurors in that, they want to be 100% sure. 100% sure. And in the case I had, the issue was really mental health issues. And that jury came back 8-4 for death. But there was some sympathy, even though there were some very ugly, very difficult facts with regard to the defendant. So the prosecutor has to look at all of these mitigating factors, and you have it on a slide. But one of the things that could come up in this case is that the defendant's capacity to appreciate wrongfulness of the defendant's conduct or to conform the defendant's conduct to the requirements of law was significantly impaired, but not so impaired as to constitute a defense to prosecution. So in other words, even if, say that a jury may not find the defendant insane, they can still consider issues around his mental health as far as a mitigating factor. In order to impose death, a verdict of death, the jury has to be unanimous. They have to find that an aggravator was proven beyond a reasonable doubt, and essentially they have to look at do the mitigators outweigh the aggravating factor, and even then they have to decide should a sentence of death be imposed. So there's no mandate that says, because that would be unconstitutional, there's no mandate that says if you find that the mitigators don't outweigh the aggravators, you have to find death. There's nothing in the law that says that. Right? So, questions?
Probably a really dumb question, but I get this from our listeners. Other states like Texas seem to be able to execute more people on death row. Is there something, I don't know if you can speak to it, that's different about their law than ours, or are they just convicted more people to death? What's the answer to that question?
It's really interesting. There was a study that was in the newspaper yesterday that's being done by a couple different professors. One of them is Sam Kamen at the University of Denver. But it was looking at the fact that in Colorado, because there are so many cases with so many homicide cases that we've had in Colorado that by which the prosecutor could have sought the death penalty because there was an aggravator that fit it, but that we haven't. The question gets raised, well, does that mean that it's now cruel and unusual punishment because we have sought it so infrequently? Whereas I think that we're in a state where if it were put to a vote, I'm not sure whether the majority of people in Colorado would favor the death penalty. Now, I think that could change. That may be different because of this case. But, I think that we've been fortunate enough to have elected prosecutors who only seek, use a death penalty case for the worst of the worst. I mean, for victims, it's so hard because prosecutors try to explain the decision not to seek the death penalty, that we're looking at kind of the most heinous cases, and you try to explain it in such a way to victims to not make them feel like, but my loved one was murdered. That's heinous. Why are you differentiating that this case is worse than the other one? So it gets very difficult. But, I think that we live in a society where prosecutors in Colorado have said we are reserving asking for the death penalty for the worst of the worst cases. And so I really think that that's been a part of it. And, one thing that I will also say is that because somebody said to me, well, the 18th Judicial District has had the most, and somebody used the word fond of the death penalty. And I kind of said, I disagree with that. First of all, I don't know a single prosecutor who is fond of the death penalty. Trying a death penalty case was probably the worst thing I ever had to do as a prosecutor. I don't believe anybody is fond of it. It is a very tough, emotional thing to go through. I will also tell you that if you look at the kinds of cases that the death penalty was sought in Arapahoe County, they were some cases that if you took those facts and put them in another county, I'm not convinced that another DA would have made a different decision. In other words, I think Arapahoe has had some very difficult terms of witness killings, some cases. And I'm not standing up here telling you that I believe in the death penalty, right? But from the prosecution standpoint, the issue isn't whether the elected prosecutor personally believes in the death penalty. The issue becomes, given the fact that we have a law that says in certain cases the death penalty may be considered, I think we've had prosecutors who have looked at that and said, I am looking for those cases then, since it is the most extreme kind of penalty that we're talking about, making sure that it's only been in the most extreme of cases that it's been sought. And I do not believe that that is true in other states.
Hendershot case, somebody mentioned that to me as a good case when it comes to mental illness defense, if you know it.
In terms of...
What was it about in layman's terms?
Without having, I have not looked at that case in so long, and so I don't, the question is, what about the Hendershot case and looking at it? It has been so long since I have looked at that case, so I don't want to talk about it and make something up.
You mentioned the current district attorney is term limited. Obviously, we'll be facing a new district attorney come January, whatever the date is specific. Assuming the preliminary hearing stays set as it is, and assuming the DA files one way or another within that 60 days before leaving office, can you talk a little bit about the discretion that the new district attorney would have, or the steps that would go on if they wanted to change course?
Well, first of all, and the question is, given the fact that the DA is term limited, what happens if after a preliminary hearing and say a decision gets made, is there a possibility that the new DA could want to change course? First of all, I believe that whoever comes in as the district attorney is going to be incredibly sensitive to the victims involved in this case and the families that are involved in this case. And so they are not, I don't believe that anybody is going to make any decision different from the course without learning everything that there is to know in terms of this case. Because keep in mind that because of the gag order, because of what's going on, that the newly elected DA is going to be coming in, possibly even knowing less than you all know, right, about what's gone on in the case. So they will have an incredible task just of trying to get up to speed with what's going on. Now, one thing I want to say about the death penalty is just because the death penalty is sought does not mean that that is the final outcome. There have been a number of cases where there was either discussions with the defense about seeking the death penalty, resulting in a plea bargain of life in prison. And there's nothing to say that that can't happen in any case. So just because the death penalty may be asked for in this case doesn't mean that a decision can't be made down the road to take that off the table. Doesn't mean that a decision can't be made to plea bargain down the road. One of the things that the district attorney has to be looking at too is what are the doctors going to be saying about his mental health? And everybody keeps assuming that insanity is going to be raised. And I will just tell you that in homicide, there's generally 3 different defenses. The first is, I didn't do it, which I just, maybe I'm putting myself out there, but I just don't think that's going to be the defense in this case. All right? The second is, yes, I did it, but I was justified. It was in the heat of passion. It was self-defense, right? So you have another of other affirmative defenses, and then you have the insanity plea. And I think all of us outsiders are looking at this and thinking that the only possible defense in this case really is going to be a mental health defense. And so, that's kind of what we look at. But from the prosecution standpoint, seeking the death penalty, they have to be looking at that mental health issue as well. Because they know that even if they're seeking the death penalty in a case and the issue's insanity, and maybe there's a bunch of doctors that are going to say he's insane, what happens if the jury comes back saying that he's insane? Guess where he goes? To the state hospital. To the state hospital. And so one of the issues for the prosecutor is going to be looking at that issue. And if they decide on the death penalty, and depending on what the evidence is in terms of sanity, do they want to take that risk? Knowing that the only thing that could happen is that he goes to the state hospital. And there is a possibility then that he can get out of the state hospital. What happens is that there is a procedure where if the doctors feel like this person maybe can be released into society or should be released, or defense attorneys believe it's time now to see, there can be what we call basically kind of a release hearing. So a hearing gets held on an insanity plea for the court to determine whether somebody should be eventually released who's been found insane. There can be all kinds of conditions placed, supervised conditions, all of those things. But from the prosecution standpoint, what they're looking at is accountability. And so whoever the prosecutor is, whether it's a new prosecutor, whoever it is going to have to look at how do we make sure that a person who, all these people took away their loved ones or permanently injured or, whatever happened, how do we make sure that person, from a prosecution standpoint, is held accountable? And so, and for the prosecution, I will tell you that accountability isn't going to mean somebody being in a state hospital. From the prosecution standpoint, what they're looking at is accountability being never getting out of prison or a sentence to death. And so, whoever is involved in making the ultimate determination, those are all the factors that they're going to have to be looking at. Aside from that, they are also talking to the families and the victims about what do they want to see happen? Do they want the prosecution to seek the death penalty? And everyone, and I will tell you, I've had so many people say, well, wouldn't you just assume that everybody wants them to seek the death penalty? And I have to tell you, my experience has been absolutely not. Absolutely not. And the Dunlap case was an example of that, where one of the victim's family said, I don't want the prosecutor to seek the death penalty. We didn't believe in it when the person was alive, and I don't want it to be that person changed our values and who we were. Right? So, the other thing that the families will be looking at, and the prosecutors will explain, is that this process, especially if the death penalty is sought, is going to be a very lengthy process. And when we're talking about if a death penalty sentence is handed down, in terms of the appellate process, you can look at Nathan Dunlap, we're talking years and years and years and years, if it ever happens.
Statistics on how infrequently an insanity defense works. Are there any statistics on the statewide level for how often it's successful versus?
If there are, I don't. I will tell you that that the defense is raised so infrequently, because you have to understand, when you are raising an insanity defense, you're saying, I did it. I did it. It takes, the issue of, did you do it, off the table. So you're starting with the premise, I did it. And the burden of proving sanity, or the burden of showing, because even though the burden's on the prosecution, defense still has to show that they were insane as the law defines it. And this is where when I did some insanity cases as a prosecutor, we really had to deal with jury selection, because people who don't know the legal definition have this idea of, something like this happens, and I had some other cases that were just awful. And so lay people think, of course the person's insane. How can anybody not be crazy to do what this person did? And what we have to talk to people about in jury selection is that the legal definition of insanity isn't kind of what we may think that somebody being insane is, that it's specifically about a mental disease or defect. Now, with regard to a sanity plea too, I will just tell you, when the issue is at trial, it's not just psychiatrists and doctors who can be called. Lay people can be called as witnesses too, by both sides. So if you have lay people who have, say you've got some people who were around this person when he was getting ready to drop out of school, who said all of a sudden he was telling us about voices, telling him to do things, things like that. Or prosecution may find witness who says, yeah, he just, he said he intended to drop out because he was tired of the program. All right, so both sides can call lay people to also testify about the issue of insanity. Going, to the death penalty, there's two phases that happens at a death penalty trial. The first phase is the guilt or innocence phase, and then the second phase is the sentencing phase. The jury makes that decision, and it is a trial in which the prosecution and the defense can put on all kinds of evidence. It may be evidence about his background, may be evidence from the victims and the impact that this crime has had on the victims that the prosecution would want. So it's essentially a trial. That one death penalty case I had, the guilt or innocence phase lasted 2 weeks. The death penalty phase lasted close to a month. Right? It's very tough on jurors. It is so tough on jurors. If you can imagine being on a panel, no matter how awful you think somebody was or how awful the things that you believe somebody did, and you have to make that decision as far as should this person die at the hands of the state. It's it's not an easy decision. One last thing that I will just tell you in terms of the process for the death penalty is there is a special set of jury selection that goes along with a capital case where the death penalty is sought. And it's referred to as death qualifying a jury, essentially. And so what you're looking for is making sure that you do not have individuals on the jury who, because of their, whether it's religious beliefs, whether it's moral beliefs, that no matter what the facts are that they hear, they could not impose the death penalty. Or by the same token, you may have people who believe, I don't care what the mitigation is, I don't care what you show. I believe under these circumstances it should be death. Lastly, with regard to jury selection, the pretrial publicity is going to be a huge issue in this case. There's been questions about is there going to be change of venue motions, what's going to happen? We don't know. But what we're seeing and what we're going to see Thursday, we're seeing all these issues of the media requests as far as the gag orders and the public's right to know versus making sure that a defendant has a right to a fair trial and how those two intersect. So there's a lot of issues in this case. It's a difficult case. It's an incredibly sad case. There are so many people involved in this, and if I can help in any way in terms of explaining some of these issues, because there are just a lot of legal issues, I'm happy to do so.
Regarding the change of venue, this is such a widely reported story. It just seems like, where do you go in this state to not have that publicity level?
Well, and the question is, where do you go in the state in terms of the publicity issue? I will just tell you that the issue in terms of change of venue isn't, do people know about this? I mean, frankly, no matter what side I was on, I would not want to have jurors on there that hadn't heard about this case, right? Because you kind of wonder, who are these people, right? So that's not the issue. The issue is, can you find people who haven't already formed an opinion about whether or not he is guilty or innocent, regardless of the evidence that they may hear in court? One of the issues that in terms of the change of venue, is going to be the issue that I will tell you in Arapahoe County, it has been really hard lately to talk to somebody that didn't know somebody who was in that movie theater, or involved in some way. And so that adds a whole other layer in terms of that opinion. So, that is just going to be we're just going to have to wait and see. And it's going to be, because it's going to be so long, I think, before we ever get to a trial stage, is it going to be easier then to find a jury in Arapahoe County, because there would have been so many months and perhaps even years removed from the time this happened. So I think, that's an issue that we'll just have to wait and see.
That jurors might be found outside of this jurisdiction but then brought back to the metro area for trial. Is that a way to do it, or if they get jurors from somewhere else, the whole case is going there?
Usually, if a case gets transferred outside of the jurisdiction, it gets transferred. I could see the possibility where jury selection may be done someplace different and then jurors transported in. I've never seen that happen. I could see that being raised as a possibility, perhaps to try to save money. So we'll just have to wait and see. Any other questions? All right.
How much can a defense attorney coach their client, or how much could they say to them, I want you to act this way, or you might consider acting this way, or realizing that down the road that's not going to help them, but just in that first case? I was under the impression that could never happen.
I believe that, I think there are some real, I'm not going to say it's unethical, I believe that there are ethical issues, that we have ethical responsibilities in terms of our preparation of our clients, in terms of not trying to deceive the court, not trying to deceive, doctors or whatever. So, I will just tell you, I know the defense attorneys in this case. Actually, one of them was one of my students many, many, many years ago, who's, I think one of the most ethical, professional. They will represent their client zealously within the boundaries of the law and within the boundaries of ethics. So that's what I can tell you.
That concludes this morning's session. Then if we have no other questions, thank you very much, Ms. Steinhauser. Judge Krieger, thank you so much. I'd also like to give some appreciation here to John Sarche, my colleague, for working through this, and of course Sarah Crocker at the bar. You guys are always the best.